Welcome to the Employers Legal Lounge with your host, Michael Sullivan Associates Managing Partner, Eric De Wames. Each month, we dive deep into a specific topic to provide you with valuable insights and guidance for navigating the complex world of California employment regulations. This podcast is provided for informational purposes and does not constitute legal advice. Only your attorney, with complete knowledge of the facts and circumstances of your situation, can determine how the relevant laws apply. Now, on to the episode.
Welcome, everybody, to Employers Legal Lounge. I am Eric De Wames, your host and managing partner at Michael Sullivan Associates Employment Law Department. Employers Legal Lounge is a podcast for employers, insurance brokers, TPAs, risk managers, anybody who really wants to be ahead of the crazy laws that we have in California and federal. So what we do is once a month as we get together, we talk about some laws that might be coming out, case law, etc. And of course, I always have special guest leaders in the industry. Today, of course, is no different. I have two wonderful people here today, leaders in the industry that are joining us. First, my dear friend, Christine Rodman, is here. Hi, Chris.
Hi.
Chris is co-owner with Mary Henderson, who couldn't be here today. Hi, Mary, who could not be here today. And it's an HR consulting firm. And I'll let Chris get into all of her other titles because there are just too many for me to list at the moment. And my dear friend, Monique Akambi, who is the Membership Initiatives Director for SHRM.
For SHRM, yes.
And I did. So we're going to be talking a little bit about that and all the wonderful things that SHRM does in a moment. And I'll let you guys introduce yourselves a little bit in a second. We also are here in person at the SHRM NorCal conference event, which it has been fantastic.
Yes.
It seems to grow every year. SHRM and the different chapters have their own conferences. SHRM NorCal up in the Bay Area, that's why we're up here. I gave my presentation yesterday on AI. Chris did hers today on leadership in the industry, and it's been a great, fantastic group. And we've had a little bit of fun here too.
Yes.
It's
Lots of fun.
Lots of fun. And speaking of Employers Legal Lounge, for my return people who view us or listen to us, of course, we're going to be talking about employment laws. And some people feel, and I don't disagree, that maybe an adult cocktail might be fun. So if you have an adult cocktail, that is okay too. Chris and I have a little champagne to enjoy, but if you don't like adult cocktails, that's okay too. Monique has her Pellegrino.
My sparkling water.
And we are here to cheers.
Yes.
Cheers to you. Thank you for being here with us.
Cheers.
Salute. And before I get into some of the laws, I want to talk about some of the legislation, things that we're watching in employment laws. First, I said, Chris, that you have a bunch of different titles. Why don't you go to it and all the wonderful things that you do, including what you're doing at Links.
So my day job, I'm a consultant. My other day job, I am the current state director for SHRM California. And my other day job is I'm also the PAC West MAC representative for SHRM, which is the highest volunteer leader role within the SHRM sphere. And essentially, I am the voice of the member for the PAC West region.
Where do you find the time? I want to know, how many different volunteer jobs can you possibly have?
I do have others, but those are the main ones.
What does a MAC do?
Basically, we support our region. So I have 10 states that I oversee, for lack of a better word. And we are the voice of the member. So we are out there in the community. We're reaching out. We're offering resources, support. We collaborate with the SHRM staff and team. Oftentimes we tag team at conferences and have a really good time trying to find out what the member wants. We do 2 surveys throughout the year that we survey both members and non-members. And we report that back to the board of directors with our recommendations. So it's
a full-time job just in and of itself. And of course, the consultant, your HR consultant, which that is two persons full-time jobs just with that. I mean, especially in California.
Especially in California and especially now.
Yeah.
You know, I've been in consulting for just over 10 years now. And then the last 5 building my business in consulting or, you know, my consulting business that links with Mary.
Yep.
And right now is unprecedented.
It's a pivotal moment
Yes.
in law, in especially, I mean, in California, we're always, you know, deciding to lead the trends. And this year is certainly no different, dealing with executive orders, dealing with legislation and the shifts in, you know, case law. It is a lot.
Yeah, it's heavy.
And if you blink, you miss it. But we're still responsible for it.
We are.
That's where these conferences are so helpful.
Oh my God. Yes.
And because, I mean, one, HR professionals in general, you are running crazy every day, right? There's, you know, so much to do and managing, and you have so many different hats. How do you watch all the changing laws and stay compliant? You know, it's practically impossible without coming together and having these trainings and everybody getting together and kind of commiserating also about what we deal with all the time. So they become really important. Monique, I know I got it right, Membership Initiative Director.
Yes.
Tell us what that means, though.
So what that means is that I have the honor and the opportunity to support our amazing HR professionals and business community, meaning our members with SHRM, not only in the state of California, which I absolutely love California.
You love it when you're here.
I'm based in Florida, so I also support Florida, New York, and New Jersey as well.
That is spread out.
Yes, and thinking about employment law in California leading the way, right?
But those are also the main states also that have the high trends in laws, New York and Chicago. Yep. And Illinois. Yep. Those are big ones.
Yep. So I get the opportunity to support our chapters in those states. So each state has chapters, their own organizations that are affiliated with SHRM, which are volunteer leader led. So just like Chris shared, being the state council director, you, Eric, as well on the state council. So amazing volunteer leaders like you all. I think the biggest piece is the connections and the relationships that I get to build with you all, but then we get to do this together, right? So speaking or thinking back to unprecedented times, now I always say now being with SHRM as an employee, I still get the chance to be in HR, but not practice HR. So, I can
supporting
empathize.
us.
I can empathize. I like this side a little better, but we still have to stay up to date, and it's hard to even stay ahead because we're in such unprecedented times. But that is what I do. So I support not only just our members in those states, I support our almost 340,000 members within SHRM.
It is a huge job, and we appreciate you for it. You do a fantastic job. We'll get a little bit more into some of the trends and the things that we're seeing, but what you said before is a really good point, which is how do we stay ahead of it? And that goes into one of my volunteer positions as co-legislative director. We watch these laws as they're coming out, and we work with the legislators. We work with other organizations like Cal Chamber and Small Business Association and others when we see what the proposed bills are, because you know some of these bills that come out, I don't know who's writing them for the legislators. Maybe it's AI. I don't know, right? But it needs work. And, you know, our job is, and of course, with our SHRM hat on, it's policy, not politics, is saying, hey, you know, I know there's good intent here, but here's what the actual impact will be. And, you know, here's our suggestions, our red lines of what might make more sense. And some legislators are welcome to it. Others are very, you know, can be a little stubborn and say, hey, no, we're never changing this. This is the way it's going to be. But we make that effort. And I can tell you with a lot of the laws that we worked with this year, we made a lot of headway. There are a few that I wanted to chat about that we have to watch out for because they are coming in if they're signed, and they're currently on the governor's desk. Some have already been signed. So I want everybody to be aware of at least those. And the big trends that we've been seeing, of course, are artificial intelligence and workplace surveillance. Those are the big ones that we're seeing in these trends. Now, we had several bills that we were watching. We were talking with the legislators about, you know, amendments. One of them was AB 1018, which was revived, which is also a artificial intelligence bill and was directed at preventing discrimination and bias, which is a great thing, but the way it was drafted was problematic because it had all of these bells and whistles in it. For example, there were some notice provisions, and then if you made a decision with AI, you had to give a certain amount of notice and appeal options. There was a lot of problems with the way that bill was. And we actually talked with the legislator on this one, and it was a no budge on changing the language. So we assumed it would go through. They'd tried it before last year. It actually didn't. It stalled. So 1018 is not happening. I bring it up because it is a 2-year bill and will come back. And this is where the trends are with artificial intelligence, making sure that we are transparent, we give employees a proper notice, that we are staying ahead of this. It's in our policies. If you don't have an AI policy, you must have one now. If you don't think your employees are using it, I guarantee you they are using it, whether it's for good or for bad. What are they uploading on ChatGPT? And that could be problematic. Is it your intellectual property? You need to have these policies so your employees know what they can be responsible for ahead of time. Because this is the world we live in now. I don't think there's an industry where we're not going to be using artificial intelligence. There's workplace surveillance was another one that we saw, and one of the bills was 1221 that had a lot of restrictions on employers and how you could use workplace surveillance. And it wasn't just regular cameras, anything associated with AI, notice provisions where you could have it, where you couldn't have it. If somebody's on a break, then you have to turn it off. If they're using their GPS on their cars that are company provided, there's certain times you can use it and you can't use it. Really complicated, and it was problematic as drafted. Also, fortunately, stalled, but a 2-year bill, and it will come back. So that's the other trend we have to watch out for, is workplace surveillance. Are we giving our employees the proper notice now? Get ready for it. Making sure that it's not obviously in private places, which should go without saying, that you have notice provisions when there are cameras so that people can see, and it's in your handbooks as well. It's another area we have to watch out for. Now, the one that is yet to be signed, which will most likely be signed, is SB 7. And SB 7 is the No Robo-Bosses law. And it really restricts our how we use AI in decision making. And I just did this presentation yesterday on HR and who is using the AI in the workplace for recruiting, for performance decisions. Almost everybody, and you were there in the room, raised their hand. And there was a time last year, maybe it was like a quarter of people were using it. Now it's almost everybody is using it. And the laws are tracking that. So with SB 7, and we don't have enough time for me to go into all the detail, but what we have to be cognizant of is, one, we can't just be making decisions based on what input AI does. If it's analyzing keystrokes or time cards or whatever it might be, we can't just trust what it comes out. It has to have human interaction in the decision making. It has such a broad definition of what artificial intelligence decision-making systems are. It's almost anything that you use that might have an impact on your decision. It's not even substantially impacts. So if it might impact your decision, use ChatGPT to research something, it had an impact on your decision. That is potentially something with SB 7. And why that matters is we have notice requirements, 30-day notice when we use it, and telling employees. And there's also a requirement after you make a decision that you have to tell employees. And you have to provide the documentation that you utilized to your employee upon request. All sorts of, and you have to save the documents for 4 years. So it is a lot. It is a lot we have to do. If this is signed, it will go in effect January 1st. We have a couple of months, as we usually do, to get everything together and make sure we're doing this right. But it is a big deal. And more likely than not, this one will get signed. I keep checking. I checked just right before we got on. If it got signed, sorry, while we're doing the podcast, these things are moving in real time. So making sure we're watching that, and if it gets signed in, really go through SB 7 and work with your employment law counsel on these issues. Now, we also have the stay or pay bill. Now, that is so a lot of us and a lot of organizations have incentives for employees, saying, hey, it's a sign-on bonus, or it's a training program, we'll pay for it. right? All these sorts of things is incentivizing, employees and onboarding, all that kind of great stuff, which is great. But what we usually do also is we have a provision. Hey, if you leave in 6 months, right, you have to pay it back, right? Or we're investing in you. And many companies have this. It prohibits stay or pay. So if we're doing this, we no longer can collect on it. And because so many companies have these, it goes effect for anything for January 1st, 2026. We have to be aware of, hey, if we're going to do this, we just can't expect it back at these points. And, this is a loss for employees too, right? This is an incentive, for them. So we just can't do that anymore if signed.
So Eric, just to clarify,
Yeah.
because again, I live in Florida, but learning California law is very exciting.
Oh, yeah, don't even get me started.
Very
California versus
exciting.
Florida.
So the employers can still offer sign-on bonuses or retention bonuses or incentives for education.
Yep.
They just cannot have an expectation that if an employee leaves
Yep.
within a period of time,
The next day.
there should
Yep.
not be an expectation
Yep.
that is paid back.
Yep.
Got it.
And it's basically the way they justified it is, hey, you're basically restricting this employee from going and working somewhere else, right? That's the, so if you say 12 months, you have to stay here,
Yeah.
they have to leave because they can't afford to pay you back, right? That was the reason behind it. But of course, employers are also going to be losing, the money on it. So we have to do it in a sense that, hey, we can't go back after them. This is money out of the pocket.
Right.
Do we just put this up to a business expense? But that's where we are now.
I have an idea.
Yeah.
Do a retention bonus.
A retention
A
bonus?
retention bonus after so many months. Is that a feasible alternative? Is to
Yes.
rather than you don't have to worry about.
You can absolutely do a retention bonus. So it's an incentive to stay.
Yes.
Yep. So retention bonuses are still, for the moment, as we're sitting here, okay. It's still okay. The other thing that we should talk about, and it seemed because I polled a bunch of people yesterday, and most people didn't realize, the Civil Rights Department, which is our department, used to be it used to be the DFEH. Now it's the CRD, which follows all of the bias, discrimination, retaliation, those types of things, has put new regulations out there for AI specifically. And they have been in effect since October 1st. So they're already here. We're already responsible for it. And a lot of people were surprised because there's not a lot in the media about this. So take a look at the CRD regulations. It is also directed at automated decision-making systems, also a very broad definition of what we're responsible for. But the kicker here is it makes not just employers responsible for potential bias, discrimination in the AI systems that they might use, but also the vendors, anybody who might be using it. So for example, if you have a recruiter who is using artificial intelligence, an outside recruiter, and you don't even know they're using artificial intelligence, but they're using artificial intelligence, and whatever system they're using happens to be discriminating based on, they're filtering out particular age, right? And then there's a lawsuit against not only the developer who did it, but the recruiter who used it, and now the employer. And it is all under the Fair Employment and Housing Act, which is typically for employers. So what this means is you might be an employer and not even realize it under the Fair Employment and Housing Act if you're utilizing these systems and it's impacting employees. So the big message here is whether you're an employer or a vendor, we have responsibilities to take a look at these contracts that we're working with when it comes to AI, even if we don't know that it's using AI. A lot of people are like, well, I don't know if it's using AI. We're responsible for knowing and how it's trained. So we have to ask our vendors, how are these trained? Is this vetted? Have you had problems? Have you had lawsuits? Those types of things. But more important, who's responsible if we get sued? If the recruiter using, a third party for AI, is the recruiter paying the bill for the attorneys and holding harmless the employer, right? Whose fault is it? Because under the legal system, if you don't have an agreement of who's responsible under the contract, Everybody's
Everyone, I
responsible.
was gonna say,
You're
is
all-
everyone responsible?
You're an employer, and you're an employer, and you're an employer. And
Mhm.
it's just another long list of that plaintiff's attorneys, we know how I love a plaintiff's attorney, will find a reason to add another pocket there. And they're already using this. Those who have listened to the podcast before know about the Raines case, which almost identical language from the Raines case, which created liability to third parties in 2023, is copied into the CRD regulations. So that came from the Raines case of extending this type of liability. So lots of, issues there. I think I'm gonna, I think I give enough on legal at this point. And so let's shift over, unless, anybody has any thoughts on it. But I just want people to kind of be watching, especially AI, workplace surveillance. Watch, follow us also on LinkedIn and Instagram. I usually post updates in these laws, and definitely in October, after these laws are in effect, we'll do a legislative update. Before I forget, I'm also part of Professionals in Human Resources, which is an affiliate of SHRM in Southern California. And we have 4 conferences coming up called CELU, California Employment Law Update, Burbank, Orange County, let's see what the other ones, San Diego, and Riverside that are coming up. And that is a great place also to get the most recent updates that are coming out in October as well. So that's all I'm going to talk about for law. I want to shift to some trends we're seeing in HR, what you're seeing as an HR consultant, Chris, with your clients. What is, what are employers really worried about right now? What are they seeing with their employees, especially in the climate that we have right now, the political climate and all the different things that are moving, immigration. I mean, there's so many different moving parts. It's like a perfect storm. What are you seeing
It's
on the ground?
really heavy right now,
Yeah.
I have to say. And, just kind of tagging on to some of the AI stuff, I feel like employees are leveraging AI to even settle disputes with their employers and bringing up, and they become smarter in the legalese and using the buzzwords. And I'm seeing a lot more of that happening with some of my clients.
You're getting some of these letters that you're like, that doesn't sound like this employee.
Yeah.
Somebody might have said, hey, ChatGPT, create a demand letter for my employer. I've seen a bunch of those too.
And so that is something new that's been coming up, especially around wage and hour and accommodations. So that's, I want to say, the hot topic right now is return to work issues, workers' comp. How long do you keep someone as an employee?
You're triggering me.
Yeah, I know.
Yep.
But you know this too, Eric. You're probably seeing the same trend. And so that's what I'm seeing.
Yeah, it is an absolute, because we watch the litigation trends, obviously. And of course, the big one has always been PAGA, right? Oh, sorry. Cheers.
That's right.
For those who
Here we go.
who are new to the podcast, cheers. Who are new to the podcast, we have a little bit of a drinking game. Every time I say the P word, we drink, and which is okay for Monique because you have sparkling water.
Yes.
But if I say it too often, then Chris and I are gonna be in trouble. So,
I was waiting for it to be said because I've heard.
Can you spell it out?
Yeah.
Does that still apply?
Yeah, I'll just say the Private Attorney General's Act.
Okay.
We'll go the long way. We'll go the long way. So, I mean, that is also, we have to be careful because those AI laws that I was talking about and privacy, workplace surveillance, those issues are now becoming Private Attorney General Act claims. They're adding those in. So this is the new trend in those. They are now piling those in. And I know we have the reform, and yes, it's great. We had a reform, and a year into it, and I just did a presentation on this. Yes, there's some great stuff and great defenses, all that wonderful thing, but it's still a broken law. It's still primarily benefiting the state that makes at least $1 billion a year on it. So they have an incentive to keep the P word around. And then the plaintiff's attorneys who are, getting rich off of it. So it is still a problem. Some people said after the reform, it'll go away. No, it is. I just was at a presentation with the Labor Workforce Development Agency head of the PAGA unit, and it was over almost 10,000 claims in this last year, which is it's skyrocketing. So it's not going down, it is skyrocketing. So, and I'm seeing them all the time. But to your point on the workers' comp return to work issue, because I got onto the P word. So sorry, I'm going to put that aside. I'm going to put that aside. But the other trend that is competing with it is fair employment and housing claims, disability claims, failure to accommodate claims that get their inception at a workers' comp. I would probably say 9 out of 10 of the fair employment and housing claims that I get, I ask the client, is there a workers' comp claim? And 9 out of 10, there are workers' comp claims that started. And it is because the plaintiff's bar is incredibly organized, right? This is the thing that they have an advantage. They have the plaintiff's bar, they communicate. That workers' comp attorney who's getting those documents from you when they send you that subpoena in the workers' comp case is getting those wage records, and they are sending them to the employment lawyer who is devising a wage and hour claim. If in the workers' comp claim we're not accommodating or there's some good reason not to, they are also telling the employment law attorney to bring a FEHA claim, and they also get a kickback from that. So it is an entire scheme, and it has turned into a huge problem. So we have to, when we have the workers' comp claims, realize that we have to do it in a smart way. Having risk managers and HR, and this is the big problem I see, risk managers and HR, they don't talk with each other for some reason. They're like, hey, workers' comp is my thing, HR is your thing, you stay in your lane, I'll stay in mine. We can't do it.
No.
We have to talk with each other. And it's just about communication. So, and I don't know what you do with your clients, but I encourage mine to say, hey, if you have a workers' comp person and HR, get together like once a month.
Collaborate.
What are those problematic? We know those employees out there that, that's the employee who's going to sue. Right. We already know which one it is. So, watch those claims, make sure that we have a strategy of how we deal with them in the right way. And we can project where it's going to go, as opposed to being behind the ball when these are being surprised when they give us this note, return to work, no restrictions, when we know that they've been unable to get out of bed for forever. What do we do with these? Who do I talk to? How? So, have a team that you work with to do these things right, because this is the main area of liability right now. I think AI and workplace surveillance will be the next wave, but currently it's return to work, like you said, workers' comp crossovers, and of course the P word. So,
and then the whole undue hardship argument doesn't really hold true anymore with the accommodation side of
what's
how
an
is
undue hardship? Right? I know I say that's argued all the time.
It is. And people think, well, it is an undue hardship because this is a pain. Right?
I know.
And I wish that was the definition of undue hardship, because it is a pain, or it's going to cost more money. And case law is very specific. Hey, you need more than it. This is, a financial inconvenience, or, you have to do a lot of work, to deal with it. Welcome to HR. It's a very high bar based on the job, your staffing, what kind of job it is. And even with those high bars, it's very rare you ever get to it. Now, sometimes if you're documenting it right, and you get that employee that every 3 months says, I need another 3 months and another 3 months. There's a period of time, if you've documented it correctly, that you can say, hey, this is indefinite leave. We don't have to, accommodate indefinite leave, and maybe it's time to separate. It's probably close to a year or more later, right? But it's still there, and you just have to be smart about it. Yep. So we are seeing the same trends on those. Those are, I think, primarily the biggest call I get is return to work. Of we just got this medical note, or we get a conflicting medical note. We have workers' comp, and they have, their own types of doctors, or QMEs, AMEs, LMNOPs, they're all their things. And they have one thing that says, hey, they can never work again, but they come with a medical note that says, hey, return to work, no restrictions. Which one do we follow? And they're dealing with that a lot right now. And the short answer to that, there's a longer answer, but the short answer is you have to do the interactive process in those moments. You don't get to choose which notes that you're relying on at all.
It's complicated.
It is so complicated, and it should be, at this point in time, should be a lot simpler if, the court would give us more bright lines to work with. But, it's California. We get the keeps on giving. So, and hey, what would people need us for if it was that simple? I like to be needed.
It's true.
I like to be needed. So tell us a little bit about kind of the trends that you're seeing with, I mean, SHRM National. I mean,
Oh my
they've been
God.
so ahead of I've been looking at the website, immigration, inclusion, all of the different issues that are hot topics. The executive order component of the website is fantastic.
Yes.
By the way, because that is also a big area of confusion
Yes.
for people. There's a drove of them and nobody knows what to follow.
Yes. So the Executive Order Hub, we all know in the beginning of the year, right, we probably had our lofty New Year's resolutions and, chasing down or understanding executive orders probably wasn't on anyone's New Year's resolution.
I remember at the end of January, it was just like,
yes, yes. Oh my God. I'm like, are we still in 2024?
What's happening? Yeah.
Yep. And SHRM sprung into action and created an executive order hub and have really been diligent and following legislation related to that. Immigration is one. Where a lot of employers are concerned. Inclusion is another, as we see a lot of administrative and executive orders that are being put in place, and employers are now having to reevaluate programs that they have, reevaluate processes. It's a lot. And Chris, you used the word that I think that really accurately describes the times that we're in, no matter what side you're on, and that is heavy, right? Because at the core of who we are, we're humans.
True.
Right.
We're humans, but at SHRM, especially in California, we recognize that California is unique. And so we have an entire
for the special ones,
people say unique, but we have an entire page that's dedicated to California specific resources.
Only one page,
right? Well, I mean, it's on microsite. Let me say that, right? Just because we recognize that HR and employment law and the business world today is just changing faster. Artificial intelligence as well. I know that we have one of our volunteer leaders that I think she has already or is getting ready to testify before Congress. Tara. Yep. Tara's getting ready, on our behalf. Right. So going back to your point of meeting with legislators and advocating on, you propose this bill or you're proposing this piece of legislation. Have you thought about it from this standpoint? Or, those blind spots or those potential impacts. So we have a saying that if you're not at the table, you're on the menu. And you're on the menu, right? And so none of us want to be a fillet, right? We want to be we want to be at the table, but it is, how do we serve our members? How do we foresee, to the best of our ability, what's coming, right? So we recognize that things change from day to day, but what does the world look like 2 years from now, 3 years from now, heck, even 10 years from now? And that seems so far away, but with the way that things are going, that is at the blink of an eye.
We do our best, but I mean, who would have predicted the year we're having?
Right. That's why I say to the best of our ability.
To the best of our ability, we do the best. But I think you nailed it. I mean, HR especially. It's what we do is we're always dealing with off the cuff new laws, shifts and changes. I mean, look at the pandemic. And all the different laws that came out, we had to deal with that. And now there's this, and there'll always be something. There will always be something, and that's why we need the community to deal with it. There will never be, a period of time like, oh, nothing's happened in HR this year. No big deal. There will always be something an emergency that we have to deal with. And having a collective, I think, is really important. You mentioned something I want to touch on because I forgot, and it's really important. You mentioned Tara Fournier, who is also on the Cal SHRM board, as well as testifying on artificial intelligence. I work closely with SHRM National, and Sean McIntosh and all those for advocacy. And we were, trying to get together, who can we find to testify to let the legislators know exactly what the impact of some of these laws are and what we're looking at. And we do call upon a lot of HR and employers out there to help us. If you're interested, don't be behind don't be behind these laws. And once they come out, we're like, okay, now we have to comply with it. And get ahead of it, because we know in February, March, April what these laws are going to look like, and let Congress know, how is this really going to impact a business? How is it going to impact a small business? can an HR professional really implement what you're asking for in reality? You know, yes, you put this on paper, but is it real? And have your voice heard. So if you're interested in that, please reach out to me. We have lots of opportunities right now. Between now and January is kind of the quiet season, obviously. But once February hits, we'll need people to be involved. So reach out to us for that. So I am so glad both of you joined me today. You are a joy to be around, both of you. This is why I people ask me why I volunteer. One is I have, you know, a passion for what we're doing, you know, legislation, advocacy, and it's wonderful, but it really is about the people. I came up here on, you know, Sunday morning, and I was looking forward to seeing my people, right?
Yes.
And our connection. And we're all busy, and we're all, pulling, 12, 14-hour days. But, you know, when it's people that understand what you're going through and people to lean on and resources, it makes all the difference in the world. So cheers to both of you. And thank you for being here.
Thank you.
Cheers. And thank you everybody out there for joining us. We will be back next month. I'll give more updates on the new laws and legislation, and to all of you. Cheers.
Thanks for listening to the Employers Legal Lounge podcast, presented by Michael Sullivan and Associates. Remember to subscribe on your favorite streaming platform so you never miss an episode. We release new content every month, ensuring you stay informed about the latest developments in California employment law. If you have any questions, topic suggestions, or would like to be a guest on our show, don't hesitate to reach out to us at msa.news/podcast. We'll see you next month with another episode of Employers Legal Lounge.